Hi, hello. Thank you for joining us on MIRS TV, where we strive to educate, inform, question issues regarding foreclosures, banking, and the economy. My name is Janet Reiner, and today is March 27, 2013. Today's topic is the Washington State Senate Financial Institution House and Insurance Committee bill of House Bill 1435. The hearing was actually on March 19th of 2013 at 1:30 p.m. And unfortunately, we were told, or at least the homeowners were told, that the original hearing was canceled and the bill was pulled due to it being a poorly written bill. And unfortunately, because of the fact that we were told that it was being canceled, no one showed up. I have here, my guest here is Shelly Erickson. Shelly, you actually testified at the hearing as well as myself. Were you surprised that it was, that after being pulled, that all of a sudden it just started to, it actually showed up as a hearing?
As an awesome bill, as a matter of fact.
Yeah. In fact, wasn't it canceled because of the fact that they were told, we were told, that it was a poorly written bill and that they had to rewrite it, and then and that nobody was going to be, the hearing was canceled, and because of that, nobody showed up. Is that correct?
Exactly.
Okay. Exactly. And how did you guys find out that it was actually being placed back on schedule?
Well, Karen Pulley let us know that it was placed back on schedule. Karen Pulley was the one that actually Senator Roger Goodman sent an email to her to cancel all of us coming. And when they had the second hearing, he actually sat up there and boasted that nobody bothered to come to the first hearing.
I wonder why.
Yes. And then he tried to get a second hearing between these two hearings just in his office one night. And he boasted that nobody showed up to that one either, but it was like very little notice. My car had to be repaired before I could go that far.
Wasn't it people found out like at 5 o'clock, the hearing was at 5 o'clock in the evening prior to the original hearing? Was that what it was? I mean,
yes.
It was like no time at all.
Exactly, exactly. I felt gamed by the senators. So?
I did. I think there's a lot of gaming going on, and people don't quite understand, some of the games, how that happens. Okay, so you find out, Karen Pulley finds out, oh my gosh, the hearing is now on. So she rounds up a whole bunch of people to all of a sudden show up. 4 of us show up. What was your reaction when you found out that it was actually on now that you didn't know before?
I just made sure I was there, but what really stunned me is Senator Roger Goodman was sitting there boasting that nobody bothered to show up to the first meeting, nobody bothered to show up that night at his office, making it sound like we didn't care and it wasn't important. There weren't that many people calling against it. It was an awesome bill, and there were so many people that had integrity and that had been working on this bill for several years, that it was an awesome bill and should be passed, and that just shocked me.
Wow.
Because he had told us it was poorly written and wasn't going to even be discussed in the first meeting.
Really? Really? Okay, so now all of a sudden we're here at the hearing. Karen Pulley rounds up as many people as she can round up. She's at the hearing. I get a call within 10 minutes and says, get down here, I need you to testify. So I go down there real quick, we testify, and we're going to hear the testimony that was actually happened. This is feed from the legislative hearing, and we'll go ahead and listen to that. Okay.
Go ahead.
My name is Janet Reiner. I'm a former real estate broker here in the state of Washington. I also have a company called Mortgage Investigative and Research Services. Our specialty is chain of title assessments. I'm not in favor of this bill for a variety of different reasons. We do chain of title assessments across the United States, and we do a lot of them here in the state of Washington. It's been my personal experience, it's been my personal experience that when we do the chain of titles here in the state of Washington, the challenge comes in is that almost every single chain of title that we've done regarding houses here in the state of Washington have been broken in one form or another. We have yet come across one chain that has not been broken. The issues here is that the deed of reconveyances that are supposedly that you want to have done are not being done at all. Okay. Now, here when you look at the title companies and you look at if you look at the title policies, one of the first things that they mention here on the title policies under Schedule B, which is a list of exceptions, the first thing that they name is the rights or claims of parties and possessions of claiming possessions not shown by the public records. The challenge comes up is the fact that when you do a chain of title assessment, one of the things that you are assuming is the fact that the lender is actually holding an original promissory note. We are finding just about every single case that they are not holding the original promissory note. They're foreclosing on imaging. They make copies of the images that they've had when they securitized the note, and they're foreclosing on that. Now, specifically, there's a case going on currently called McDonald versus One West Bank, currently going on, in which One West Bank, one of the vice presidents named Charles Boyle, states in testimony that they do at times endorse copies of notes. And now what that means is that homeowners are being foreclosed on by endorsed copies of notes, not the original. The challenge comes in is that according to the law, you need to be foreclosed on by originals, not copies, not endorsed copies. That's a big problem. Okay? The other issue is the fact, the other issue is the fact that the entities that purport to have foreclosed, the entities that purport to have the original are in fact not the entities that have legal standing. And the reason for that is when we do chain of title assessments, we go around and we look at the chain of title in minutiae detail. A lot of times the deeds are not done, or they're done incorrectly. The entities are not correct. The dates are not correct. The pooling and servicing is not correct. There's robo-signers, the notary fraud. There's a whole plethora of other things. When you allow an entity to be able to file a deed of reconveyance without the proper documentation, without the proper chain, what you're doing is you're opening up a whole can of worms that allows a homeowner's house to be stolen. Is that what you want to do for your constituents?
Hey, does anyone have any questions? Okay, thank you very much.
Thank you.
Now, Denny, you said you wanted to come up here. Holly, did you want to change, or did you? No, you don't want to do it. Okay, that's cool. All right. You do? All right. This will be it.
Thank you, Mr. Chair. Stu Halson here, now representing the Washington Land Title Association, and I just wanted to bring up a few things in response to what we just heard. This is not about foreclosures of deeds of trust. The talk about mediation and foreclosure counseling and all of that type of thing is totally irrelevant to this. This is not about anybody losing their home. This is about somebody wanting to sell their home. They want to get the documentation so that they can sell it. And this bill merely sets up a default system of notices and filings that can be used when the beneficiary, lender, and trustee don't do what they're supposed to do. You know, a lot of the stuff that you just heard, and Denny may not like this, but we're dealing in the title industry with the environment in which we're in. One of your last witnesses talked about securitization. Yeah, that probably is the problem that really is concerned with them, because Wall Street securitized a lot of these mortgages, packaged them up, they're owned somewhere off here, and the collections are run by a servicing agent here. You know, we've never required, and this law doesn't require an original note to be done in order to do that. The current statute doesn't require that. We're releasing collateral. We're not releasing the note in regards to this. You're not going to be able to change what Wall Street did with those securitizations of all these things. So we're dealing with the situation on the ground, how we're trying to sell your houses. And if you start requiring the original note that has been gone through, I don't know how many hands, but the collection is being done by a servicing company that we know, if you require that original note, none of you will ever be able to sell your property. You just won't. And that's my weak understanding of this thing. But this bill has nothing to do with the problems that really seem to have these previous witnesses worked up. We're just trying to get these transactions through. And I would remind the committee members, we're title insurance companies doing closings. We do this closing and you sell your property, we're insuring the person buying it from anything that might be a problem there. And this bill only releases the lien. If there are any lawsuits or whatever that might come of transactions that they talk about of fraud, those can still be used. It's just the property gets to be able to be transferred. All those other potential suits out there still exist, if in fact they're there. So that's my weak, perhaps, explanation in response to what we've just heard, and I'll defer to Denny and Holly.
Good afternoon, Mr. Chairman, honorable members of the committee. For the record, my name is Denny Eliason. I'm here on behalf of the Washington Bankers Association. We're a trade association.
Wow. Wow. Isn't it amazing the words that come out of this attorney's mouth? This, the last person to testify was, who was this?
Stuart Hulson.
And he's actually the attorney for the Washington Land Association. And he's an attorney, so he knows what he's talking about. And the words that came out of his mouth was what?
Was exactly this. This is a quote. He said that if this legislature requires the original promissory note to be required prior to reconveyance, that none of your properties will be able to be sold or be reconveyed.
None?
None.
None. N-O-N-E. So if they are not able to convey or at least be able to show the original promissory note, and he says this, that if that's a requirement, that nobody will be able to transfer ownership to property.
Correct.
Okay. Now here's from what I understand. Now correct me if I'm wrong. In a foreclosure process or any type of a transfer, the original promissory note needs to be produced.
Correct.
Okay. And in this bill, he said you cannot be able to expect that because there's not capable of being able to produce the original note.
Correct.
Okay, so let's step back a little bit. This bill is really all about agency relationship. They want to redefine the agency relationship. And what else do they want to do?
They want to skirt around the original documents and the original parties of interest.
Okay.
In order to reconvey a house with no documents to sell a house, which affects, as he says, all mortgages, not just a few mortgages. It's going to affect all mortgages.
Okay. Now, how is that? Now, this is what a lot of homeowners are going to come who are watching the show. They may not understand exactly what the ramifications are. They may not exactly understand how this is going to affect them. So I want you to be able to in very plain language, because you're highly intelligent, and I need you to dumb it down, not dumb it down, but I need you to lower it a little bit. So how is this going to hurt the homeowners?
How it's going to hurt the homeowners is when they don't know who they're really paying off. They don't know who really owns their loan, and it won't be brought to the table. The real parties of interest and the real notes don't have to be brought to the table now. If this, they do right now, but if this bill passes, they won't have to be brought to the table.
So anyone producing a copy of a note, can all of a sudden show up and say, I don't have the original, but I'll sign an indemnity agreement, and I'll just say I'll indemnify the title company as long as you just go ahead and close. Is that correct?
Correct.
Okay.
Correct.
And how does that affect the homeowner?
They may not be paying off the right party. They may not even owe that party.
Or it may be a party that thinks they have legal standing, but may not have legal standing.
Correct.
And one of the challenges that people need to understand is that prior to a foreclosure, prior to closing on a property, there has to be a valid, unbroken chain of title that goes from the time of original purchase, and proper documentation has to be recorded within the county recorder's office, and they have to be able to validate how they got the note, how the original promissory note, and be able to produce the original promissory note to be able to have legal standing to foreclose. Is that correct?
Correct.
Okay.
There's not going to be any proof of chain of title anymore. There's just the chain of title has been broken, it's been ruined and destroyed, and this is a cover-up to skirt around all that destruction. So how do you ever really know that you own some property? How do you know that you can ever pay it off? And this actually, if this bill passes, it's going to give the power to the title agency to reconvey it without any proof of real documents, and they can actually proclaim that they weren't ever answered by the original parties, so that they're going to get quiet title, and it could be an improper person, a wrongdoer that never had any business or any weren't party to the note, claiming the money and getting paid instead of the people that should have been paid. It's just absolutely crazy. So
this bill basically sort of, like you said, it sort of skirts around the issue. They sort of know that something is wrong. The title company realizes that something's wrong, and they don't want to come out and say, we have all these lenders, and they're not able to produce the note. They don't have proper chain of title, but we need to close on this anyway. So this sort of walks around and the real issue. And what happens now? I want you to be able to feel comfortable with what I'm saying is it sort of walks around the issue about what's supposed to happen what the law says is supposed to happen. Is that correct?
Yes, it's getting around the laws that protect you right now. It's going to unprotect you by this bill. It's going to protect the banks. I call it a banker's bill.
Well, and that brings up to another issue. This bill is one of many bills. Do you find that there's a lot of bills coming forward now, and homeowners are not aware of this? And thank God for you and Karen Pooley and some
yourself.
of these, and I didn't want to say that, but there's a whole group of people that have been so there have been advocates for the homeowners and working behind the scenes for homeowners such as yourself, so that we are able to we're able to bring these issues to you so that you're aware of it now. So how many bills are you aware of that they're bringing forward or changing?
Gosh, probably 4 or 5 bills that I am aware of, and I couldn't tell you all the numbers right now, but it's in every state. What they're doing is the walls are closing in on the banks, and they've been proving counterfeit notes, just like the James and McDonald case, where there's 2 counterfeit notes that have been evidenced on 1 mortgage, and the Docs company and the LPS company have pled guilty to counterfeit notes. Full, complete documentation for mortgages, $85 for all the counterfeit notes, and so they're trying to skirt around, because the notes that are out there, obviously by the statement by Stuart Helson, that there are no notes. So the notes out there have to all be counterfeit, because if there's no notes, the notes coming into the court system and into the county records have to be counterfeit.
Right, and you brought up a really good point. In the case of McDonald versus One West Bank here in the state of Washington, it was discovered that there were 2 promissory notes, and the endorsement on those 2 promissory notes were different. One was on the bottom left-hand side, and the second endorsement was on the bottom center. And Charles Boyle, who's one of the vice presidents of One West Bank, stated in testimony for that trial, he stated on record saying that he was confronted with the question, how is it that there's 2 promissory notes, and how is it that they were different? And he stated in records that says sometimes they endorse copies of the note. So that becomes a very problematic issue, because of the fact that if there's a difference between a copy of the note and an endorsement of a copy of the note, because the endorsement is basically a stamp that says this is an original, and this becomes an instrument for a negotiable instrument.
It's the same as a counterfeit $100 bill.
Right, it's exactly. And we use that example quite frequently as a $100 bill. If you make a Xerox copy of a $100 bill, that's not a negotiable instrument. It's the same thing with the promissory note. When you make a copy of a promissory note and they endorse it, all of a sudden they're saying it's a negotiable instrument, when in fact it's not. So the question comes up, if they're making copies of these promissory notes, how many copies are out there?
It could be in the millions. With the Docs company, they claim, well, they've made over $65 million making fabricated notes. So if you divide that by $85 for a full set, look at how many notes are there.
Right. And what you brought up a really good issue is that several weeks ago, Lorraine Brown, who was the president of DocX, actually pled guilty for a plethora of charges. And one of the things that she has done, and one of the documents that we have, is her it's her rate sheet. And in her rate sheet, she states very explicitly that I'll give you an example. The cured defective mortgages is $12.95 plus shipping and handling. Here's an interesting one. To create a lost note affidavit, it only costs the banks $12.95 plus shipping and handling. And to create a note allonge is $12.95. And here's the thing that I find very funny is to recreate an entire collateral file is $95. So does that shock you?
It should be shocking everybody out there. It should be on main media news. People should be irate, because there's millions and millions of documents. They only like to keep it low or keyed, saying, well, she's admitted to over 1 million documents. It's probably more like 65 million documents or more. Yes, and she's a small part of this. She's just a small person compared to the amount of people that actually are out there that are continuing to do this, like Solomon Edwards Company. They proclaim to a main media, a media on the phone, that their specialty is forging notes, allonges, and assignments. Solomon Edwards is 975 Solomon Edwards employees were hired by Promontory Financial Group to scour through the independent foreclosure reviews for the people here recently. So all of the 4.5 million mortgages that were supposed to be gone through by an independent foreclosure review company were gone through by Promontory Financial Group that hired 975 employees from Sullivan Edwards. Both of those companies are noted now to have been put together by people from the high up in the government in the White House area to actually suppress and hide fraud in large companies.
So not only do we have DocX that was purported to manufacture millions of documents over 3 years.
It's a small part of the iceberg.
Oh my gosh.
Yeah, there are many more companies that have done the same thing, so it's huge.
It's huge. So homeowners now, the ones that are in foreclosures, you don't even have to be in foreclosure. So basically, you don't necessarily have to be in foreclosure. If you own a house, you need to be able to look at your recorded documents and look at the documents that you have in your chain of title, and you got to question whether or not they've been manufactured, right?
Yes, because whenever they decide that they think they can pay it off or sell it, they won't be able to. That's why one of the women testifying on the Senate committee said she'd been trying to sell a house and close it for 6 years. This wasn't a party that was in foreclosure. They had to sell, the house was being sold, and she wasn't able to sell it. Well, that's going to happen, if it probably hasn't already happened, to massive amounts of people because there is no proof of documentation.
So this is something, I think that the question here is, why is it why is it that homeowners in general have not been told? Why do you think this has not been in the mainstream media? I would think that as important as this is, as important as this is for over 70 million homes across the United States, with the fact that it affects people who are in foreclosure, not in foreclosure, has been foreclosed on, why is it, do you think, that the mainstream media has chosen not, and I use the words very specifically, chosen not to report it? Why do you think that
Because it is so huge, and the main media is mostly owned by the title insurance companies, whoever backs them. I think you know more about that than I do, and who actually owns most of the main media and most of the newspapers in the area. They've all been bought out by people that are behind this scheme, so they don't want you to know what's going on because it is so huge. And the banks are able to get away with their corruption, and the title companies can get away with it too with Schedule Bs.
Well, explain this. Can you explain the Schedule B?
Yeah,
now,
Schedule B is on every title insurance company that I know of, and this is just two different ones here, Chicago Title and I guess this is all Chicago Title. I think Ticor is another one I've read.
Stewart Title.
Stewart Title. It's on all of them, and as you noticed, Stuart Halston also said there's no problem here because the title companies insure the new sales. Well, they insure them because they're giving what I consider fake insurance because they have Schedule B.
No,
and
read what it says.
On this one it says rights or claims of parties in possession or claiming possession not shown by public records. So this is their exceptions, their exemptions. They don't cover this. They don't cover defects, liens, encumbrances, adverse claims, or other matters, if any, created first appearing in the public records or attached subsequent to the effective date, but prior to the date of the proposed insured acquires for values of record, the estate of interest or mortgage thereon covered by the commitment. Rights or claims of parties in possession not shown on public records. Basically, they are not covering clouded or slandered title.
So here's a mistake that a lot of homeowners make, is the fact that they think, oh, well, if there's a mistake, the title company will take care of it and take care of me.
Well, the title companies are taking care of the banks. They're not taking care of the homeowners.
And that's a huge problem for a lot of homeowners to know.
The realtors aren't even notified. One of my customers is a realtor, and she told me, well, the banks have all been taken care of. They're paying their dues to the people through this independent foreclosure review that is also caused by the $25 billion settlement, and that everything's been fixed. And she's wrong. They're being lied to, that it's being fixed by Schedule B and false information that the public's being reimbursed and that everything has been straightened out is false information to the public.
I think the challenge here is that the public really believes the stuff, because what did Hitler's propaganda's ministry once said? If you tell a lie big enough, and often enough, people will believe it.
Yes, and that's exactly it. That goes along with even the deadbeat lie. The deadbeat aren't the banks. They just repeated and repeated the deadbeats are the homeowners, but they haven't, just like today we brought out, or on your last program, that it's not necessarily people that are in foreclosure or in default that are losing their homes.
That's right.
They're going after all properties.
That's right.
And eventually they'll go after probably yours, because no matter who you are, you can't prove that where the original authentic documents are. Everybody out there that owns property is susceptible to this crime.
That's right.
Because there are no authentic notes. There are no authentic documents to prove reconveyances. And Bill 1435 is going to put everybody, all constituents in the state, in harm's way, because they're going to skirt around this, and they're going to be able to sell properties that have been stolen, fraudulently stolen, like the gentleman that was on your last program.
Right.
They're going to be able to do what they did to him. They're going to be able to do what they do to everybody I am aware of that is in foreclosure, that were in modification plans. Mine was a modification. I was selling a modification. I mean, I was paying my modification plan. I wasn't in trouble. I get a letter saying your modification plan has been unapproved. You're going to, we are going to consider your modification partial payments now, and so you are in default. We're coming after your house.
And that happens a lot with homeowners, where you go into a modification, and this, in general, this is happening on people nationwide, where you actually apply for a modification, you get accepted for a modification, you make the modification payments, and then next thing you know, you're on a dual track to foreclosure. And that seems to be a common element for a vast majority of people. And I think that's very problematic, because of the fact that when you follow the rules and you make an agreement and you follow the rules and you do what you say you're going to do, but all of a sudden, 6 months down the road, all of a sudden you get a foreclosure notice saying, whoops, we decided not to accept your modification. And so it becomes very problematic for homeowners, because homeowners go into this with good faith, and then what happens is the banks turn around and they change their mind for whatever reason, and all of a sudden the homeowner's in a quandary, because 6 months down the road, when you consider that's problem, it's considered a partial payment. Now you have to make up 6 months of partial payments.
They won't let you. They do not let you. They will not allow you to do it. I have another client that I'll just call the B client, and they have two businesses, and they're slow because of the economy. So they went in and protected themselves, they thought, with a modification from HAL, from Chase, the same bank I'm dealing with, and they were approved for a $6 reduction. $6. And they refused it. They said, we need to wait for something better than $6. And the bank said, no, we will only accept a $6 reduced payment from you. We won't accept the original payment. This is what we've approved. So for 9 months, they begrudgingly paid a $6 reduced payment. After the 9 months, they get the same letter I am given, and said that it's only being considered a partial payment now, so they're in default. So they tried to come up with all the money. They said, no big deal, we'll just come up with all the money and we'll catch it up. Just like Duncan tried to pay off and get the payoff figures. Kathy's family tried to get the payoff figures. They would not allow it to be done, and they are now I just talked with that family, and they think in 2 months they'll be walked out of their house.
Wow. And this is not a family that was so-called a deadbeat homeowner.
No, run to business, have a beautiful home on Lake Tapps, had everything going in life, and now their family's been put through this stress and this hell for over 3 years, and maybe walked out of their home.
And this brings up, getting back to the House Bill 1435. A lot of these senators, such as the co-sponsors of this bill 1435 is Senator Goodman as well as Senator Neely. And every homeowner who listens to this needs to contact their own respective senators and ask them very pertinent questions. Why are these legislation that are so detrimental to the homeowners? Why is your senator allowing these bills to go through when you, as homeowners, elected them? That's a question that you need to have.
I'd like to also add that Pam Roach just voted verbally very loud today on a video that I was watching in the Senate on the same bill, and voted. They all voted it in, including Pam Roach. So you need to contact Pam Roach and ask why she's supporting such a bad bill that can harm the homeowners in this state.
Right, and it's not just here in Washington State. This is going on across all 50 states. And this is a question that homeowners need to ask their respective senators and representatives. Are you protecting my interest? Now remember, you voted them in. You have a right to know. is this going on? And you need to question it. So here's the question that I have. With Senator Goodman and Senator Goodman, Senator Roach, and Neely, because those two, Senator Goodman and Senator Neely, are co-sponsors of this bill, do you feel as if they knew what was going on, or they were just ignorant about what was going on?
I know that they absolutely know. I've sent enough information, and they know. And then Roger Goodman, in the video of the Senate meeting that we were told not to come to, he flat out told the Senate committee that he was talking to that the lenders don't know who owns the notes. So he knows what's going on.
He knows this.
Yes, that's right on video also. So they do know what's going on. So I am just shocked that they voted this bill through and that they've been pushing this. I felt we were gamed in the original message not to come. Senator Goodman was the one in the second video stating that nobody bothered coming, like we didn't matter, that we were irresponsible. And he's the one that told us not to come. Yeah. Exactly. So I feel like we've been gamed by our senators.
Wow. So in closing, I'd like for everyone to realize that these issues that are going on with legislation, you need to be painfully, consciously aware. It has to be individual. You have to take it upon yourself to contact your senator, your legislator, and really question whether or not this, what it is you can do. And I hope our conversation today has been informative, educational, and inspirational to your life. Shelly, I really appreciate you coming on and telling us what's going on.
I appreciate you asking me.
Absolutely. And once again, make it your point and focus in life to be able to really contact your senators and legislators and find out. If you wish to join us on our shows, in our future shows, to help investigate and disseminate information about the foreclosure, mortgage fraud, government misuse, or any other issues that you may feel useful and important, please contact us and at janet.reiner@mirsnow.com or visit us at mirsnow.com. Thank you for joining us on MIRS TV, and we look forward to seeing you again on our next show. Thank you.
Thank you. I think that was so